নমস্কার, চলবে রণজিতে আপনাদের সবাইকে স্বাগত। আপনাদের ভালো রাখতে, সমাজকে ভালো করার প্রয়াসী এই প্রতিবেদনের অবতারণা শুরু হয়েছে দ্বিতীয় দিনের ডিএ মামলা, এবং শুরুতেই মাতিয়ে দিলেন, দেখুন একটু আমি, গোপাল সুব্রমণিয়াম, যিনি রাজ্য সরকারি কর্মচারীদের হয়ে লড়াইটা করবেন আজকে সারাদিন, এবং তার সাথে অবশ্যই বিকাশ রঞ্জন ভট্টাচার্য রয়েছেন, অন্যরাও রয়েছেন। একটু শুরুটা দেখুন, দেখলে বুঝে যাবেন। দ্য মর্নিং শোজ দ্য ডে।
First time it was considered was 16th of February 2017, when the application was dismissed. Against that vote, we filed a writ petition before the High Court. The writ petition came up before a division bench. The division bench looked into the matter, came to a conclusion that because of the rules as they are framed and the notifications issued by the state of West Bengal, there arose a legally enforceable right. But the extent to which that right must be given effect to was a matter which the tribunal should apply its mind. It held in our favor that there was a legally enforceable right, but it needed, therefore, fresh consideration by the tribunal. Well, that judgment is important because many of the submissions which were urged yesterday were in fact urged in that proceeding, and those petitions came to be allowed. That judgment, of the division bench of the Calcutta High Court is of the 31st of August 2018.
Page 368.
That's right, that same judgment. That judgment, was sought to be reviewed by the state. That review also, came to be dismissed.
Page 444.
That's right, Then afterwards, we now come to the application coming back to the tribunal, and the tribunal, has allowed the original application. The various paragraphs which were read, it was suggested that the tribunal had simply overstepped its jurisdiction and had issued some sort of a mandamus, and, to borrow the words of Mr. Divan, something alien to the rules was attempted by the tribunal. It was extraneous, to borrow his expression, to the rules and the notifications. Then, the matter naturally goes to the division bench once again. There are two judgments of learned judges. Both these judgments, have found four conclusions. The first conclusion is on the question of dearness allowance being claimable as a legally enforceable right has been held by the previous division bench, and the matter has acquired finality. That's the first. The second conclusion is that we read the rules as they are framed clearly suggest that in order to adjust against the cost of inflation, the rule is indeed indicative of the fact that dearness allowance would be payable upon revision from time to time. The concurring judgment, in fact, very elaborately traces this entire AICPI IW for right from the time it evolved in 1944. It's quite useful as a historical account. But then, what is important is that the learned judge comes to the conclusion that on an interpretation of the rule, both on its own terms and as understood by the government in its notification, this was meant to operate as a time-to-time benefit which had to be given because the very purpose of dearness allowance is to protect the real value of money. If one understands this aspect, that dearness allowance is really to protect the true purchasing power which your wages or your salaries are meant to achieve, and keeping in mind the revisions which take place, there is an adjustment, and that is not something which is a matter of bounty, nor is it, my lord, a matter of, if I may say so, a claimable right per se. But if, my lord, the rules give this as a part of your emoluments, based upon an acceptance of the recommendations of the pay commission, then, my lord, I submit that becomes a compellable obligation. So, my lord, the right to get existing emoluments reckoned in accordance with the rules is a legal right vested in me by the rules and imposes, my lord, what we call in jurisprudence a corresponding obligation or a duty on the state to abide by that rule. And, my lord, that rule, therefore, can legitimately be the subject of a mandamus. Because, my lord, a mandamus always is in the context of a public duty or, my lord, a statutory duty or a constitutional duty. Here it is a case of a statutory duty which is enjoined by the rule. Now, my lord, may I straightaway take your lordships to the first division bench judgment and only 2 or 3 paras to satisfy you that that judgment, my lord, analyzed these defenses. This very same judgment of 1954 Supreme Court, which was cited by Mr. Divan yesterday, that is, my lord, that state of Madhya Pradesh judgment, was also examined, and the court distinguished it on the ground that the words of Fundamental Rule 44, which was being interpreted by Justice Venkatramaya in that judgment, provided for the word may. And because there was the word may, this was a discretion which was vested in the government. So, my lord, this is one aspect. The court also dealt with other judgments and said that the law is, if there is a pay commission, it is not binding on the state government. The state government may accept it, may not accept it, may accept it in part, may accept it in total. Now, my lord, the court, however, says that if it is accepted and is translated into a rule, then that rule imposes an obligation. So then the rule, well, a rule could also permit discretion. Now the question is, my learned friends in their interpretation want to invest this rule with having induced a point A, after which, my lord, there is only a remnant of discretion. And that construction, my lord, is the one which I seek to displace in my submission for your lordship's kind consideration. Because this is, my lord, really the scope of contest. Now, my lord, I will also place those paras of the administrative tribunal. My lord, they were placed, they were rendered, my lord, in a context. The context was that, my lord, the central government was making it a practice to give dearness allowance when necessary, twice a year, because, my lord, twice a year you have the benefit of the discovery of the index. This word average, which your lordships find, is really, my lord, an average of 12 months, which is actually the basis of arriving at that figure 536 in the year 2005. So that is why you have the word average index, because it's over a period, weighted average, my lord, for 12 months. Now, having said that, my lord, let me take you straight away first to the rule and also explain, my lord, that it is time to time, because that is the purpose of the rule. So may I straight away do that, so that we deal with the heart of the matter.
We want to request.
Please, certainly, my lord.
We are conscious of this fact that we were conscious that you're going to argue that the division bench has already settled the issue and they have not filed any appeal, so therefore a judicator would apply. You are aware of that. Now, we would request you for one thing, because it is going to have pan-India implications. You please proceed as though we are hearing it for the first time.
Certainly.
Because we have to lay down the law.
Certainly, my lord. Certainly. There's no difficulty
So
at
that's
all.
how we leave it.
No difficulty at all.
Mr. Divan,
Yes.
Sibyl,
Yes.
they were focusing only on the rule.
Yes.
So therefore, how do we read the rule?
Yes.
to your benefit and advantage is what we want you to address
Certainly, Manoj.
first, and then we'll
Yes, certainly, certainly.
the manner in which.
Certainly. And Manoj, even if it is pan-India, I'm not, if I may say so with respect, I'm not overwhelmed by it because